Assalamu alaikum everyone, and welcome to our keynote session for the LSE Future of Pakistan Conference 2022. The topic at hand that we're going to be talking about now is the Supreme Court and emerging jurisprudence. Chairing the event, we have Professor Sarah Paterson, who is the Program Director of the LSE LLB at the LSE Law School. And before I invite Professor Paterson to introduce our distinguished speaker for the session, I would just like to make a few announcements. So you are not allowed to take any photos or videos during the talk. You are expected to maintain discipline and order while the speaker is speaking. After Justice Shah's speech, the floor will be open for a Q&A. If you have any questions, please raise your hand, and someone from the host team will come to you with a microphone. Your questions must be appropriate and precise, and the speaker reserves the right to not answer them if they deem them unfit. With that, over to you, Professor Paterson.
Thank you, Mustafa. So it's my absolute honour to introduce Mr. Justice Shah. We are so very, very pleased that you're with us this afternoon. It was quite difficult choosing some things for the introduction. Our distinguished speaker has so many achievements, there was a risk that the introduction was going to be longer than the speech, as this is very much edited highlights. So Mr. Justice Shah was elevated to the bench at the Lahore High Court in 2009 and then to the Supreme Court of Pakistan in 2018. He has a passion for teaching, so that will be dear to many of us in the room, and taught for almost 2 decades at an incredibly impressive variety of institutions. And his special interests are incredibly numerous: constitutional law, human rights, climate and water justice, environmental sustainability, disability rights, criminology, digital surveillance, and privacy and proportionality. And what really, I think, stuck out for me was the phenomenal work in judicial reform, spearheading the establishment of the alternative dispute resolution centres in the Punjab, setting up the first ever gender-based violence court in Lahore, establishing a child court in Lahore and criminal and civil model courts, and introducing case management and court automation in the Punjab. And that work is carried on in the Supreme Court, so establishing e-courts in the Supreme Court in Pakistan, and I hope maybe we will hear some of that when Mr. Justice Shah speaks. And also an honorary bencher of Lincoln's Inn here in London, so numerous connections with our great city. So without further ado, I will hand over to Mr. Justice Shah.
Thank you, Sarah. That was a very kind introduction. Thank you so much. So, Assalamu alaikum to everybody here. The idea this afternoon would be to talk about, well, let me just qualify, the judges hardly speak. I mean, they speak through their judgments, but I'll try to make an effort today and share some of my thoughts on how the Supreme Court is basically what is the future, or how should be the future of the judiciary in Pakistan. And I want to the topic says the Supreme Court and the emerging jurisprudence, but I want to add to it and the future, which is more important for me, you see. So let me come up with some qualifications in the beginning. I do not represent the institution today. I don't represent the Supreme Court of Pakistan today. So I'm here in my personal capacity, and therefore I want to talk about the future. I want to talk about ideas that I've been thinking about for a long time, as to how could we refashion, remodel our judiciary, how could we make it more robust and more dynamic, because I believe that if the judiciary is independent and the judiciary is robust and dynamic, half the problem is solved in the country. So your country could be, Pakistan could take off if we have a very strong, independent judiciary. So I think as far as future of Pakistan is concerned, it is, I think, critical to think that if we were to remodel and refashion our judiciary, that is perhaps, you can't not talk about the judiciary when you're talking about future of Pakistan, because I think it's critical to have a word and see what we can do about it. So let me also qualify that every institution makes mistakes, and I'm sure there are a number of mistakes made by my institution too. But let's just forget about that. Let's learn from the mistakes that we've made, and let's move on, you see. I want to talk about the future. I want to talk about new things, innovations, inventiveness, and what we can do. And let's not be chained by the mistakes of the past, you see. And I don't really want to criticize the past or the previous judges. I just want to look at the future, what we can do today. So the roadmap is absolutely clear for us. We need to walk the Constitution, you see, and protect the constitutional boundaries. That is absolutely clear. It is very simple for the judiciary to move forward. Everything is there in the Constitution, and all we need to do is follow the Constitution, and everything falls in place. That's as simple as that. I mean, that might not be the case when you talk about the executive or the legislature, because the construct there is very different. There we're talking about majoritarian, construct, and there are electorates, and there are compromises, and there are negotiations, and whatnot. We don't have that in our system. It's very simple. We just have to follow the Constitution and the law, which is very easy said, but hasn't been done in the past. And so we need to just talk about some of the areas that I'll share with you in just a while. So any dialogue on the future of Pakistan would be totally incomplete without an independent or a courageous, creative, and smart judiciary. And I want to use those words, you see. We need to be creative. We need to be smart. It can't be a status quo. We've had that for too long. For 75 years, we've been doing nothing. We've never really thought about reforming our institution. There have been no reforms, actually. So I think it's high time that we thought about something more creative, something more smart, something more innovative. And yes, of course, there's no question about being independent. There's no question about integrity, though they are the basic, requirements for any judiciary to be functional. So when I say the judiciary, I also want to qualify that I mean the justice sector, actually. And justice sector includes the judges, the bar, of course, and you'll be the members of the bar one day, most of you sitting here. And I want to talk about the bar today because that is a key factor in the future of our institution. I also want to talk about, I include in the justice sector the Attorney General's office, the state lawyers, the prosecutor generals, the Ministry of Law, the academics in Pakistan, and the law schools. So to me, this big sector needs a revisit. If we want to reschedule, if we want to refashion, remodel the judiciary, then we actually need to think about the entire justice sector as a whole, because I don't think we can sort of tweak with just the judges part of it or the jurisprudence part of it. You need to look at the whole thing and see if we can revamp it. So our 75 years of history tells us that there have been compromises, and I must admit that, yes. And we have been very specific, person-specific jurisprudence at times, which is not correct. We should have been rather principle-based jurisprudence, And that is something that I want to talk about later on. So over the years, we've cared less about our own house. I mean, there were times that we raised this question with our judges and the senior judges, that it's about time that we thought about our institution inwardly. We need to do something about our institution. But we're too busy, worried about the Prime Minister and worried about executive and other policy issues, to which I'll come in a minute. So over the years, we've been cared less about our own house, but rather judicialized politics, interfered into policy, overstepped our jurisdiction, blurred the lines of separation of power, and had little time to remodel our institution. So it's about time that we talk about these things now. So what better thing to do today, and I'll be very happy to take questions and inputs and suggestions from your side. What better thing to talk about today when you talk about the future of Pakistan than to talk about refashioning and strengthening the judiciary, making it smart and dynamic, a judiciary which is grounded in the constitutional values, and that's very important. It goes without saying that a strong and independent judiciary is the backbone of a robust and dynamic democracy. And I am absolutely clear in my mind that if we were to have a strong and efficient and independent judiciary, we can't have any other problem in the country. I think lots of problems get sorted if we have a strong judiciary. So while the executive and the legislature, as I've mentioned earlier, have a majoritarian sort of construct, they have to cater to the electorate and play in the political market, dealing with various interest groups, making compromises and accommodations. We don't have to worry about all that, and we just have to move on. So what can we do and how do we go about it? So if you lend me your ears for just less than half an hour, I'll just share with you some of the suggestions or solutions or things that I've thought about over the years, and how could we go about refashioning things for ourselves. But before I do that, I thought it's better to share for the young lawyers who are about to go back to Pakistan maybe, to talk about what do we have as our constitutional background. See, what are we talking about when we keep talking about constitution? What are those constitutional values that we have in Pakistan that we need to follow, and the basis on the basis of which we'll probably sort of move forward and restructure our court. So according to our constitution, we are a constitutional democracy. The state shall exercise its powers, says the constitution, authority through the chosen representatives of the people. So it's very clear. It's the people are at the heart of the constitution, and it's a constitutional democracy. Hence the term public interest and welfare of the people comes first and foremost. So this is first constitutional value and very important for us. The Constitution goes ahead and says that the principles of democracy, freedom, equality, tolerance, and social justice are critical principles for us. Social justice, there's a lot to it. When we talk about principles of freedom, I mean, it's an endless conversation can take place. Principles of freedom, I mean, you can talk about so much and include so much in it. Then we have fundamental rights. It says that wherein shall be guaranteed fundamental rights, including equality of status and opportunity, level playing field, giving status to everybody, distributive justice, social, economic, and political justice, freedom and political justice, freedom of thought, belief, faith, worship, subject to law, and public morality. These are the principles and the constitutional values our Constitution keeps talking about. Wherein minorities shall freely profess and practice their religions and develop their cultures. Very important. Provisions shall be made to safeguard the legitimate interests and minorities of the backward and depressed classes. So keep thinking of the Hazaras in Balochistan, the Shidis in Sindh, you see. Our Constitution is very clear about minorities. You can go and do whatever you want to do. Any minority could go profess, propagate its religion. But that's not how things are, just because perhaps the court is not strong enough. And if the court is strong enough, you start implementing the Constitution, and nobody will have a problem. How come the Hazaras are not being heard, and how come the Shidis are not being heard? If they were to come to court, the court should be able to do things. So the Constitution is very clear what we are supposed to do. So while we talk about constitutional democracy, we have a formal side of democracy, or a facial side of democracy, which is right to vote, elections, political parties, and all that, which is a formal side. But there is a more substantive part of democracy. The very core of democracy is not only the elections or the right to vote or the political parties, but more substantive values like separation of powers, independence of judiciary, rule of law, and human rights. This is at the very core of democracy. So do not take democracy to be just elections and majority and all that. It is more to it. Then we talk about rule of law. Now, rule of law also has two sides to it. One is a formal side and one is more substantive side. So rule of law would normally mean, simply put, means the king is no more the law is the king. Well, rule of law at one level means rule of laws. Well, dictators also have laws. Hitler also had laws. But would that make it a rule of law in our context? No. Then there is an inner core value of the rule of law also, which needs to be appreciated. The constitutional values and principles, the laws must ensure individual liberty, freedom, privacy, and other safeguards. That turns it into a real substantive rule of law that we're talking about, rather than just, rules that we have to follow. So laws must be in public interest. It's a very important term. You might have come across while reading laws or while, reading judgments. Public interest is a very important concept, and I think to protect and preserve equality, tolerance, life, and liberty, everything leads towards public interest, and the government or the state or the executive must fashion its laws its legislation in a way that promotes public interest. So as I said, the Constitution talks about public interest. The Constitution talks about public and the interests of the people. So it has to be fashioned in that direction. So without protection of the rights of the people of human rights, there can be no democracy or no justification of democracy. So rule of law, human rights are important aspects and constitutional values that the Constitution gives us on which we need to fashion our judiciary. So judiciary is an important constituent of the rule of law. It is the courthouse that ultimately protects and preserves the rule of law. Individual freedoms, human dignity, minority rights, tolerance, social justice, the court will have to deal with all these things, and court will have to do this. Judiciary is therefore the custodian of that rule of law that we're talking about. A weak judiciary weakens the rule of law in the country. So how is the judiciary manned? I mean, the judiciary is manned by judges. Us, you see, we're sitting at the Supreme Court, and the judges sitting in the High Court, in the district courts. What is our responsibility? All this has to be done by us. I mean, we talk about all these, high-flying principles, and they have to be enforced by us, the individuals who are sitting behind the Supreme Court, behind the High Court. So the oath that I take as a judge under the Constitution is very important. And I say this because, if you're talking about remodeling and refashioning and thinking how to reconstruct the judiciary for the future, I think we need to really go back to our Constitution and understand what our oath is saying. And every judge sitting in the Supreme Court needs to understand what this oath is telling him. And oath in our setting or in our religion, we just having this conversation with God, saying, I'm going to uphold all this. You see, it's a very important kind of a relationship where I'm undertaking this with a superior being, saying that I will follow this. So I think it's quite a charge and an obligation on me to go sit in the Supreme Court and not follow the Constitution. Just scares the hell out of me. I don't know how this happens. It has been happening in the past that you might not follow the Constitution, yet you've taken an oath before God that you will preserve and protect the Constitution. I think it means so much to me personally, and it should mean a lot to judges who sit in the Supreme Court. So it says, or in the High Court for that matter. So, for example, the oath says that I will discharge my duties in accordance with the Constitution and the law. Very simple. It says, I'll preserve, protect, and defend the Constitution. I will do right to all manner of people without fear or favor, affection, or ill will. I mean, this says it all. I mean, if you were to just simply follow your oath, is there any possibility that anything could go wrong? I mean, how would you decide otherwise? You'll decide according to what the Constitution says, what the law says. This is very simple to my mind. I mean, I don't know where the complication is. I mean, why would anybody not follow the oath and not protect the Constitution or, not dispense justice without fear or favor? It does not really matter who appears before us. It does not matter which institution appears before us. We just have to follow the law. So that is the kind of courage, that's the kind of strength, perhaps, that's required to sit on the bench. If anybody feels or has doubts in his mind that he can't carry the day, I think he need to, do something else in life rather than become a judge. So I think being a judge requires a lot more courage and strength. And I think everybody must first, ask that question, can I do this or not? Because otherwise you're violating the Constitution in and out every day that you dispense justice. So that is the foundation, that's the constitutional construct on the basis of which the Supreme Court or the High Court or the judiciary is being structured. So this brings me to another core values of a good judge, you see. A good judge needs to be patient, open-minded, courteous, tactful, courageous, punctual, firm, whatever, humility. He must have humility, he must have common sense and all that. But more important is that he must have courage. So I underline two most important traits that, other than competence and knowledge, which are required for a judge, is judicial courage and judicial integrity. I think these are two very important aspects. Without fear or favor, affection or ill will, says the oath, that points towards two things, judicial courage and judicial integrity. So what is judicial courage? Means that a judge decides according to the Constitution and he speaks truth to power. I mean, he's not scared as to who appears before him, whose case is he deciding. He should be courageous enough to decide according to the Constitution. It's easy said. I underline this, it's easy said than done. So that's the gap. We need to get to the level where we're able to do it, you see. We need to achieve that. Integrity, on the other hand, is not that a judge is not influenced by position, power, color, identity, race, wealth, relationship, or political inclination. Judge needs to be totally apolitical. He can't have any affiliations. And if he does, he must recuse from sitting on the bench. These principles are pretty simple and straightforward. A judge under our Constitution cannot agree to anything undemocratic, to my mind. It would be against his grain if he were to decide anything undemocratic. We've had in the past where we allowed a number of undemocratic things that the state has done, but I fail to understand how a judge cannot possibly sign off on anything undemocratic. It is so ingrained and so embedded in our character as a judge that I could probably break, but I cannot sign a document or a judgment which would be undemocratic. But it's happened in the past. So how would judges in the future be, and how should they be, actually? A judge must be an embodiment of all these constitutional values we talk about. He must be. He must be progressive. He must promote and protect human rights. That's how he should be structured as an individual. He should be innovative and creative and in touch with the world with an eye on comparative jurisprudence, technology, and new ideas. That's what we require. If you really want to have a future of the country and of the judiciary, you need to have these people come in and do something very exciting about it. So let me just share a few cases with you, some of the jurisprudence that's recently evolved, where these principles were put to work. The ones that I've just talked about. I've talked about, the constitutional values. I've talked about the oath of the judge. I've talked about what is the Constitution or the character of a judge. So putting these values in place, some of our judges have created some jurisprudence recently, just to give you an idea that how things can go right also, if you were to just simply follow the constitutional spirit as such. So, for example, recently the Supreme Court came up with a judgment talking about judicial overreach. They said we cannot interfere in policy issues. We need to understand the separation of powers very clearly. We can't just, poke our nose into every matter that the executive is doing or the legislature is doing. We have our own jurisdiction, and we need to be very clear on our jurisdiction. The minute you step out of your jurisdiction and start interfering in policy matters or matters relating to the executive or the legislature, that is called sort of judicial overreach, and you cannot do that. So judges passing orders which are not anchored in law and do not draw their legitimacy from the Constitution unnerve the other branches of the government and shake the very foundations of our democracy. Interference in policy amounts to judicial overreach. Now, this is something that came after, and I'll talk about suo motu in just a while. These judgments have just recently come out, and I'm quite sure just prior to these judgments, there was a huge suo motu world going on, and we're all aware of that, and all sorts of interference that was going on all around us. So perhaps the judiciary or the judges later on realized that that was not on, and we need to sort of remain within our limits. The second area, which is also very important, and these are some of the areas that I'm talking about, with recent judgments, keeping in view, the context that we're talking about, that we've also sort of constitutionalized criminal law or decolonized criminal law in many ways. So the law of bail seems to have gone through a bit of a change at the Supreme Court. Bail is a rule and denial is an exception. So moving on from the colonial mindset, bail has been granted on the constitutional context, or constitutional grounds for the first time. Our criminal procedure code is way back in 19th century, 1898 or so, and our bails were granted on the basis of that statutory framework, whereas our Constitution is full of fundamental rights relating to criminal law, but they were never used. The criminal law was never utilized by the criminal judges, and that was a bit funny and odd also, I don't know why, but so recently judges have brought in the Constitution, and they've been considering the right to liberty in the context of right to right to dignity, right to fair trial, constitutional principles that are there. So grounds of bail have been fashioned on constitutional values and the constitutional recognized human rights called the fundamental rights. So for grant of bail, reasonable grounds or insufficiency of incriminating material drawn from the fundamental rights to liberty, dignity, fair trial, and protection against arbitrary arrest, and not detention guaranteed by the Constitution. And not under Section 497, if you're familiar with our code in Pakistan of the Criminal Procedure Code of 1898, which talks about Section 497. And judgments so far earlier were based under Section 497, which has a limiting feature, and maybe there comes a stage where we sort of strike that provision at some stage and declare it unconstitutional, because it says you can't grant bail to a person who's committed crime of more than, which has a punishment of more than 10 years or has a punishment of death attached to it, unless there is a further inquiry in the matter. So depriving a person of his fundamental rights is to be read in all laws, now says the new jurisprudence, dealing or interfering with his liberty. In the absence of sufficient incriminating material, depriving the accused of his liberty and freedom even for a single day is unconscionable and below human dignity. This jurisprudence has also been a part and parcel of the NAB laws in Pakistan. NAB law says you can't get bail, but then the constitutional provisions have carved out space for bail under the NAB laws now, and some of the jurisprudence that I've just read talks about NAB laws also. There's also, within the criminal law, a limitation in a post-arrest case that you cannot come to court if you've crossed the period of limitation seeking a post-arrest bail. That too has been refashioned by the court, saying a person who might be in prison does not have access to justice, and limitation cannot be a ground, cannot be deprived of right of liberty, dignity, and fair trial. So that period of limitation does not really work for anybody who is behind bars and is applying for bail. Then we also have a bail on statutory ground. That means that if you have you're behind bars and your trial hasn't concluded in a year in matters or in offenses which have a penalty of less than a year, less than 10 years, or less than life or less than death, and if your trial has not been concluded for 2 years in matters of death or life imprisonment, you could, through a statutory right, apply for a bail. Now, over the years, this has been applied in a way that people who come to court, the court examines that whether at all, there are two exceptions to this, that whether at all the accused wanted to delay the trial himself, or is he a hardened criminal. These are the two exceptions to this principle. So the court has been over the years examining this, and they've been mathematically counting the days. When did the accused, or the lawyer of the accused did not appear in court? And so basically, if you have about 30 or 40 adjournments, which your lawyer got those adjournments because he was busy before the Supreme Court, he was busy before some other court, they get attributed to you, and they say you were not pursuing the trial yourself, and that's why you cannot be granted the statutory bail. But that aspect has been changed, and now bringing in the constitutional provisions, we've said that unless there is a concerted effort by the accused, or there's a design to delay his trial, he can be granted bail on statutory grounds. And to be a hardened criminal, there has to be a huge record which shows that he's a hardened criminal, otherwise bail ought to be granted. So the statutory bail over the years has also been changed now, and we've brought in these fundamental right principles, constitutional principles, in redefining the scope of statutory bail. Similar things have happened as far as pre-arrest bail is concerned. We've changed that also, and there has been a major change in bringing this about. Then moving on, we've also now looked at science. You see, science is very important. Science needs to come to the courtroom. We can't just say no to science and technology. So recently, the Supreme Court has really talked about DNA as a gold standard test, as a forensic test in cases of rape, in cases of murder, which was earlier not so. And we were not going in that direction. But we brought that in because a judge must enjoy a good sense and understanding of science. As science grows, so do techniques and tools of forensic science, and we need to understand science. Therefore, courts must be open to developments in forensic science and embrace new techniques to resolve a dispute, provided the said techniques are well established in the scientific community. So DNA evidence was considered as a gold standard to establish the identity of an accused. DNA test, due to its inaccuracy and accuracy and conclusiveness, was one of the strongest corroborative pieces of evidence. Science and technology needs to join hands, and in future, we need to bring in fingerprinting, we need to bring in footprinting, genome editing, genetics, etc. That's the direction we need to follow to bring science into our courtroom, which wasn't happening earlier. In the cases of identification parade, if you probably, I don't know if you have it here or how does it work, but if there's an accused that you do not know and you've seen him on the site of the crime, there is an identification parade that takes place that you identify this is the person at the scene of the crime. Now that process has also gone through a change, and the court has relied on a lot of scientific material to understand that memory lapses and memory doesn't stay the same way. If the witness is testifying after about a month or so, his memory would not be the same at the time when he saw the incident. A number of other factors influence his memory. And that has been included, like the stress of the occasion, the weapon that was being used, the duration of the incident, the distance, the lighting, the memory decay. This part of the scientific research has now been brought into the concept of identification parade, which was earlier not the case. We've also looked at mental illness recently in a major case that's come out, where a trial court is put to notice regarding the issue of incapability of accused to understand the proceedings of trial and to make his or her defense the same should be taken seriously while keeping in mind the importance of procedural fairness and due process guaranteed under the Constitution and the law. Carrying out the death sentence on a condemned prisoner who, due to mental illness, is unable to comprehend the rationale and the reason behind his punishment does not meet the ends of justice. So mental illness and the understanding of mental illness has also come in a recent judgment called the Safiya Bano case. So this is where we bring in the understanding of neuroscience, psychology, psychiatry into the courtroom, which wasn't happening earlier. So we're opening doors to science. So then the gender issue has also come closer to the court, and the court has tried to understand gender perspective. In the recent judgment on rape, which is to relate with the two-finger test, the Supreme Court has very clearly said that two-finger test or the virginity test of the rape victim has no scientific justification, and the alleged immoral character of a rape victim has no relevance under the law in a rape trial. This wasn't the case earlier, and there were two-finger tests going on earlier. Dragging sexual history of the rape survivor into the case by making observations about her body is an affront to the reputation and honor of the rape survivor and offends her right to dignity guaranteed under Article 14 of the Constitution. A woman, whatever her sexual character or reputation, says the court, may be, is entitled to equal protection of law. No one has the license to invade her person or violate her privacy on the ground of her alleged immoral character. So this again, the perspective on gender and understanding that this two-finger test was abolished in Pakistan after this judgment, and the Supreme Court has directed this can't be carried out by any of the medical officers in the area. Then we've also worked on and come up with disability laws, and the jurisprudence on disability has developed, and the paradigm is disability has shifted from charity to investment, exclusion to inclusion, and sympathy to right-based approach. Earlier, we didn't have many cases relating to disability, but the court, once again, relying on the fundamental rights. And I keep going back to the constitutional values because there's a lot of energy there, and you could do so much innovation with your constitutional values if the judge wants to do that. So the human rights model or rights is now what the dignity model is based on, and embodies values and principles of dignity, respect, equality, social justice to the persons with different abilities. And recently, the Supreme Court has confirmed a judgment from the High Court where a visually impaired person joined the Foreign Office in Pakistan. He is now working. In fact, I recently met him. He is now working at the Foreign Office. There are two others working in the DMG service, which is a field job, and they are visually impaired. We in Punjab now have a judge, a civil judge, who's visually impaired, and he's a judge of the Civil Court of Punjab. And you have the assistive technology available to you. They have the right to go work. So disability law has also moved over the years, looking at the constitutional values and the principles that we have. And let me also just point out that I sit on the Rhodes Scholar Committee, and last year we selected the candidate for the Rhodes Scholar from Pakistan. She was from a Pakistani student, and she's currently studying at Oxford, and she's visually impaired. And she was the brightest of the lot that we'd interviewed last year. So I'm just saying that visual impairment or disability of any sort should not come in the way in deciding matters, because the Constitution gives you that energy to deal with such matters and push such people into mainstream, if you wish. Climate change has been another big area where our judgments are coming out. Earlier, the High Court came up with the Laghari judgment, which has been hailed internationally, talks about climate change and says, gives directions to the state to follow their climate change policy that the federal government had and was lying on the shelf for a long time. But recently, in a cement case where a cement plant was being enhanced, or they wanted to add a new plant to it in the area of Kalar Kahar, if you're sort of familiar with the area, if you drive on the motorway, you get to see Kalar Kahar on the right. It's a water scarce area. The cement plants, some of them have come up there and they wanted to expand, and the court held that no, that cannot be done. It's a water scarce area, and they connected water scarcity of Pakistan with the issue of climate change. And they said, we need to start protecting the country. This cannot possibly happen because climate change, this will have a devastating effect on people, because Pakistan is a country, strategy has to be adaptation, because we're not really contributing to the greenhouse gases, but we are being affected by climate change. So our entire jurisprudence, as opposed to jurisprudence coming out from the other countries in the West, is adaptive jurisprudence rather than mitigational jurisprudence. So this is also a recent judgment which talks about adaptive jurisprudence coming out of Pakistan, saying we need to start protecting our country against any possible damage that climate change can do, and we need to take steps accordingly. So that's one. Then the environmental principles that were framed in this judgment are very important, you see. For the first time, the Supreme Court recognizes, and anybody who's studying environment here, that the international environmental principles were read along with the fundamental rights and the constitutional values. And the court recognized the international environmental law principles like precautionary principle, in dubio pro natura, which is just a recent principle that has come out in one of the conferences in Brazil, and the Supreme Court has picked it up. It says, if you are in doubt, err on the side of nature. So in dubio pro natura, environmental legal personhood has now for the first time been recognized by the Supreme Court, and I'll read that. And climate change, climate justice, and water justice are also concepts which our jurisprudence is now talking about, which is pretty cutting edge to my mind. So robust democracies, and I quote from the judgment, robust democracies need to be climate democracies in order to save the world and our further generations from being colonized at the hands of climate change. The preambular constitutional value of democracy under our Constitution is in effect climate democracy. If we wish to actualize our Constitution and the fundamental rights guaranteed under the Constitution for ourselves and our future generations, sustainable development means development that meets the needs of the present generation without compromising the ability of future generations to meet their needs, and it is in step with our constitutional values of social and economic justice. Legal personhood has for the first time carved out by the Supreme Court. By alluding to the environmental legal personhood, the court for the first time in Pakistan opened up a window of extending legal rights to natural objects. Now, this is pretty cutting edge to my mind. The human-centric approach has moved on to a more biocentric approach. Any harm to the environment may be taken into consideration in its own right. The tree and the plants also have rights to survival and to a clean environment. So this is something that was said in the cement case recently. We've also talked about academic freedom recently, that we're not supposed to interfere in how universities are to be run, what curriculum they need to have, what is their internal disciplinary process. Supreme Court has nothing to do with it, you see. We need to start protecting academic freedom of institutions and protect and honor their autonomy. So in one of the medical college cases, the court held that democracy, human rights, and the rule of law cannot become and remain a reality unless higher education institutions and staff and students enjoy economic freedom and institutional autonomy. Conversely, we cannot have genuine democracy unless the higher education and research community is able to inquire freely. Higher education institutions are places that have to be imbued with democratic culture, and that in turn helps promote democratic values in the wider society. Universities are the playgrounds of democracy, and more freedom and independence they enjoy, the more free thinkers and leaders they will produce. The academic, administrative, and disciplinary autonomy of university must be therefore respected. Previously, the courts were quite actively interfering in the way universities function, and so we said, stay away. I mean, there's nothing to do with us. It's a policy matter. We must have academic freedom at the institutions and let them worry about it. This was just a snapshot of some of the interesting things happening in Pakistan. And since we've started kind of, looking at the constitutional principles, it also gives you an example that the constitutional principles, fundamental rights are followed and, deeply considered, could take you in the right direction, and you can advance and progress and come up with innovative solutions, remedies for people. So now let's get to the future part of it. How could we build this institution into something more dynamic? And these are some of my thoughts, how we could really turn things around, if we wish, if everybody wants to do it. So building the institution is building trust and public confidence of the people in the institution. Unless people trust us, unless people have confidence in the judiciary, that's the basic test, you see. People need to have confidence. That's how we function. That's what our strength is, the public confidence and public trust. So we need to be independent. We need to look at our integrity issues. We look at our transparency, our efficiency, our knowledge, and our research base. You see, these are some of the areas that we... So how do we go forward? Now, first thing that comes to my mind is that we need to be very clear about our jurisdiction. We cannot start interfering, and I've already said this earlier, we need to stay away from judicial overreach. And you all know this has happened in the past. The court has committed judicial overreach many times. We need to understand our jurisdiction would be the first thing and stop interfering in the domain of the legislature and the executive. We just attend to the list that we have. We have 2 million cases in Pakistan. We better attend to those cases rather than attending to areas which are not ours, you see. So we need to stay within that domain. The other thing is that we need to understand that there is judicial activism, which is legal and which is acceptable, and then there is judicial restraint. And we need to understand when to use both. Judicial review has these two options. You could have judicial activism, you could have judicial restraint. But you need to be intelligent enough to understand when to go for judicial restraint and when to go for judicial activism. Both are legal concepts, but it has to be understood. The two approaches need to be applied cautiously. So some find change and innovation more important. Depends on the judges. Some judges are more conservative and might go for judicial restraint. The other are slightly more liberal, progressive, and might go for judicial activism. But this has to be understood and applied cautiously. In the army chief case, which people might have objections to it and might have some questions relating to it, judicial restraint was exercised. In a sacked employee's case recently, judicial restraint was employed. So depending on what the nature of the case is, you could understand that and apply that accordingly. But judicial review cannot be used to promote politics or to attend to political aims or play politics. That's not the scope of judicial review. It has sadly happened in the past. I don't want to get into the areas, but judicial review can only be to promote the constitutional values. It cannot be to play politics in any manner. Coming to suo moto, it has been abused over the years, Article 184(3), and we need to have a serious check on this, absolutely serious. The judge is not a king, or Supreme Court is not a kingdom, you see. We need to be very careful. We are applying the Constitution. I'm bound by the Constitution and the law and have to act in accordance with law like any other institution. Only matters of enforcement of fundamental rights of public importance might invoke suo moto at times, only to promote fundamental rights. Suo moto cannot be employed to curb fundamental rights in any manner. So, to my mind, if at all suo moto is to be exercised, it could be exercised to pull up the minorities or to help the backward and depressed classes that are mentioned in the Constitution. It is just a people-centric provision, and it could only be done to attend to a class which is really in trouble, and sparingly done, and that's about it. We can't sort of interfere in other things, and I don't want to go into the areas that we've interfered in, but that's not the purpose of suo moto to my mind. I think we need to curtail that seriously. And unless there is any other remedy available, let those remedies be taken, and you just cut to this only if there is a serious issue of fundamental rights of a particular class, and that too downtrodden and weak and poor and vulnerable, that you probably get. But suo moto cannot be used to jump into a political thicket, you see, to understand, resolve political issues, not our problem. We are not going to use suo moto for policy areas. That is not our area. And suo moto cannot be exercised by a particular bench or by one individual or by the Chief Justice. It must go to a larger bench on which the person who's proposing to take a suo moto action is not a member. I think it should have a bench of 7 members at least who would just decide whether at all we're going to entertain this matter of suo moto or not, which has been proposed by a judge of the court. So that is required, and we need to provide an appeal in case the court goes into a suo moto action. There must be an appellate forum to the suo moto. On the judicial governance, largely, institutions run through consensus, participatory approach, and ownership run through. So Supreme Court has to, or the judiciary has to be run through some sort of a collective board. Our entire set of institutions, be it Supreme Court or the High Court, is very Chief Justice-centric. Everything, Chief Justice calls the shots, but you must understand the Chief Justice is the first person to leave the system. He's there for a couple of months. We don't have a tenure system, and I'm proposing that we must have a minimum tenure of a Chief Justice for 3 years or 2 years or so. If the Chief Justice is there for a couple of months and the whole system sucks up to him, there's no way that we can sort of evolve or come up with judicial reforms or policies or anything to that effect, because there's no long term there. So there has to be, we need to rethink that the courts need to function through a board, you see. So in case the Chief Justice is gone, the policies stay, and there is continuity in the institutions. Lack of continuity has been a biggest problem that Pakistan is facing. A Chief Justice comes for 3 months, comes up with whatever he decides to do. It's all undone by the next chap. So 1 step forward, 10 steps backwards, and that's where we are right now. We're just doing this in and out for several years. So I think we need to have a constitutional amendment to talk about a tenure for a Chief Justice. And a Chief Justice of the Supreme Court cannot be a Chief Justice unless he's been a Chief Justice of the High Court. It is critical that he's had administrative experience and an understanding of administration before he takes over the apex court and looks at the national judicial system. He needs to have that experience. So not everybody should become a Chief Justice. This is something on the internal governance that we need to consider. The elevation to the bench is critical also. We need to make sure, and it's very important, that there is integrity, there is courage, and there's competence, there's diversity. Yes, I fully agree with diversity. I'm very happy that we have a female judge now at the Supreme Court. But that's not as a policy. That's a one-off thing, you see. We need to have a policy. Why can't this happen at the High Court? Why can't this happen at the district courts, you see? Just one-off person elevated to the Supreme Court, very good. I welcome that. But this should have been a part of a big policy, which is not there. There is no policy. So what do we do next? I mean, will there be a next judge coming to the Supreme Court? We don't know, because it's just a one-off thing. So yes, diversity, Minorities also need to come to the Supreme Court, and we need to have that. But not only the Supreme Court, we need to do that for the High Court. We have 500 female judges in the district courts. We need to talk about that too, you see. Where is, diversity and gender preference there? I mean, we're not really thinking about that. So we need to think about this entire elevation business. I think it should be advertised. I think we need to reach out to the bars of the country to send their names who should be elevated to the High Court. And there should be a test, and there should be a proper, interview, and we need to consider people from all across the province or the country when we are considering somebody for the courts. And it should not be based on just selection on our own or selection of a few people. That's important. And I think Supreme Court material would be somebody who's creative and inventive. And if he's not inventive and he's not liberal and he's not creative, I think the person is not supposed to come to the Supreme Court, because Supreme Court doesn't require operational judges who would just look at criminal law, look at civil law. That's not what we need. We need somebody who looks at policy, so he's higher than the civil and criminal law, so that he creates jurisprudence for you. He has to be slightly different. So that's what we need to start considering. So, and judicial reforms are important. Now, it's very sad, you see. I don't know if there have been judicial reforms in the real sense in our country. It's been 75 years, and I think we need to sit down and do some serious judicial reforms. And for example, case management itself is just a basic reform system that we need to do. Bring in technology, bring in artificial intelligence. How are we going to deal with 2 million cases? No clue. Nobody has any idea what to do with it. Case management is an accepted technology, accepted technique all over the world. We need to bring that in. We need to start moving cases. We need to start categorizing cases of children, women, infirm people, old people. They can't just be there. I mean, it's a cliche. In Pakistan, generations go through cases. I mean, one big reform, if that can take place in Pakistan, is that the matter or the list should be decided in a maximum of 1 year, from trial court till the Supreme Court, and you're done. And that will revolutionize the country. If you were to decide a case from the trial court till the Supreme Court in 1 year, you're out of the justice system, you have changed the way the country works, totally changed the way the country works. But this period, from trial court to the Supreme Court, takes 25 years. The rent seekers, you do whatever you want to do with the system. I can get an injunction and sit on it for the rest of my life, destroy the economy, destroy everything, cannot function. So one reform, if you were to ask me, is just make sure that the shelf life of a case in Pakistan is not more than 1 year. You're out of my justice system, do whatever you want to do, but you're out of the justice system in 1 year. That needs to be worked on. And I think we can, with the artificial intelligence, with technology, we can come up with that. We've also come up with video linking. I mean, and that's been a major, Justice Khosa started it, but it's a great lesson, and COVID has really reaffirmed that. I think we need to get into this video linking business, and a lot of adjournments, which is a curse in Pakistan. 80% of our work gets affected by adjournments, could be sorted through video linking, which is now very established technology. We're also promoting, there was a judgment recently where, I was with the dissenting judges, but the majority judges didn't agree. We wanted live streaming of our proceedings. Every court is doing live streaming. What could be more transparent? If, especially 184.3, which are public interest cases, which says it is of public importance. How would public not know what's happening in a 184.3 case? It should be live streamed. And that is something that we need to be heading towards. That adds transparency. Let people understand. Let courts have no walls. Let people see what's happening inside the courts. The more you open it, the more efficient, more transparent you make it, you see. And that's how we should be looking at the Supreme Court. We need to also time our hearing. You see, if you come to Pakistan, you see, Mr. Raja is sitting here. They could go on endlessly arguing their case, you see. We need to have timing. We need to have, the Supreme Court in US, we could, and come up with skeleton arguments, you see, so that we move on to the next case. We just can't go on for hours and hours on a particular case and keep hearing the lawyer repeatedly, because they have their own issues of articulation. We need to also move on to mediation. You see, we cannot decide all these cases. We cannot decide 2 million cases. We need to move on to ADR. We started off with mediation. I think the country needs to be infested with mediating centers or mediation centers where people are resolving the disputes. Family issues, rent issues, corporate issues, tax issues could be resolved through mediation, and that's the future. We need to encourage and move towards mediation. and that is we're lagging behind. We don't have a proper arbitration mechanism. We don't have commercial arbitration centers in Pakistan. We need to get in that direction and move in that direction also. We've also come up with, and I will share that with you, but we need to do it at a national level, we've come up with the gender-based violence court, you see. Now that's very important. In a normal court, if a rape victim cannot sit, because if you look at the kind of people in a court, if the several trials are going on at the same time, the court is jam-packed, and just imagine a rape victim sitting there and the lawyer asking all sorts of indecent questions from her. That's what we've changed. We've come up with a gender-based violence court. This one trial takes place at a time. The victim need not be in the courtroom. She could be sitting in the the room next door. Through teleconferencing, she could make a deposition. And since the establishment of GBV court in Pakistan, in Punjab, just 1 or 2 courts so far, the more cases have started coming in, and the conviction rate has also gone up because people can now start attending to this. And I must refer to the Salman Raja case in this regard because they gave the guidelines, and Mr. Raja is sitting here. He had taken a matter to the court, and the guidelines were given on how to really deal with it. And we picked up those guidelines and used them in the GBV courts also. So that's the way forward. You see, we come up with child courts. Why should a child suffer through litigation for 25 years? Why can't we have child courts and define what child cases are so that they're fast-tracked and we get them out of the system as quickly as possible, not bring them into the mainstream court complex or the courthouse also. Our child courts are made on the side in Punjab, and so we get done with the child cases and, get them going so that they can just attend to other things in life. We need to also base our entire court structures on research. Research is seriously lacking. We don't have academics in Pakistan, legal academics, and I'll be encouraging people that and I'll be talking about in a minute, that we need to now start thinking about this avenue of having judicial academics, legal academics in Pakistan. But the court structure need to have a research center. We've recently established a research center at the Supreme Court, but we want it going all over the country. Without research, without looking at other jurisdictions, how could you enrich your jurisprudence? So these are the things to be done, you see, having a more research-based future for our courts. Role of the bar is important. That's where you also come in. Some of the people, students who will probably join the bar soon in Pakistan, that largely, and I hope people agree with me, largely the quality is very poor scholastically. They're not really there to assist the court that much, except a very small fringe. The majority of the lawyers are not really very articulate or well prepared. So I want to say that we keep talking about the bar and the bench relationship in Pakistan, and you're probably aware of how unruly at times our bar gets in Pakistan and has been damaging any reform or any progress. Like in the High Court in Lahore, we tried to bring in technology and an enterprise system to look into case management, and the bar was creating all sorts of problems, saying, no, this is not right because it affects their transparency or whatever their interests might be, their vested interests. So to me, the real relationship there is no other relationship between the bar and the bench. The only relationship should be intellectual. Whatever, if you have good lawyers who are coming up with wonderful arguments, you're enriching the judge actually, and he's enriching the jurisprudence. So it works in that direction. But if nothing comes from the lawyer, the quality of the judgments will also suffer. Actually, the bar is supposed to develop judges by coming up with, really, arguments that carry weight. So I think this relationship is missing. There is a very poor level of our bar because of mushrooming of number of law colleges all over the country has lowered the academic, the legal quality of our education also. So we need to shut that down and try to develop a more robust and a more articulate bar which could do something and actually help the judges intellectually also. We need to start working on adjournments. We need to start working on costs, costs are totally missing in Pakistan. I mean, you could just take 50 adjournments and still there are no costs. Islamabad has now come up with an act relating to costs, and one of the judges in the Islamabad High Court has now come up with some judgments imposing costs, and I think we need to head in that direction. But there are new avenues also for young lawyers sitting here coming to Pakistan. Lawyering is one option. Of course, you can join a law firm, you could be going into litigation, or you could go into transactional work. But then there are consultancies also, and then more importantly, you can get into judicial, legal academics, you see. There's a dearth of academics in Pakistan, so you might want to teach at law schools in Pakistan, might become an academic, and that would be a great support to the judiciary also, because that's totally missing in Pakistan. You could go into teaching, which is also required. We don't have good teachers, and that would be important. But also, we now have online portals, and I think whatever you call them, the new techies in the legal system could join these organizations, like Quoting the Law, you must have heard, Qanun Dan. These are all online apps, and a lot of people work for them, like Insaf Camp, the Motasab PK, a number of other things, like Vakil Online, Bench Book for the judges, .pk, and you see the number of such technologies. There's a Gather Sense, Lawyer, Her is there, which talks about a platform for women and women lawyers. So this is another area which is developing, where the lawyers could come in and start working. The last area which is very important is the district judiciary. Nobody talks about district judiciary. Now, this is the saddest part, you see. District judiciary is the frontline courts where the list starts in the original jurisdiction, the magisterial courts and the civil judges of the world. We do not care about them. The system does not cater to them. There's a lack of communication between the tiers and the district judiciary, and it does not perform. It's a very demoralized structure. I wonder if anybody sitting here graduating from LSE, going back to Pakistan, would like to opt for a district judiciary to become a civil judge. No, because the system is so messed up. It is not encouraging enough. That needs to be restructured, refashioned. Seriously, we need to start thinking on how can we bring more energy into district judiciary, more sort of efficiency into the district judiciary. How could we train them? How could we develop a judicial university for them? How could we, bring them up to speed? District judiciary is our biggest problem and has to be attended to. And lastly, I think it's very important to have a serious awareness program. We need to have a spokesperson for the judiciary in Pakistan. Everybody talks about their blogs. There are, you keep on hearing all these blogs against or for the judiciary, but there's nothing from the judiciary. There is no spokesperson of the Pakistan judiciary who talks about cases, who tells people what we're doing every day, how many cases we're deciding, and what are the interesting things that we're doing. I mean, I had a chance to go to Brazil, and they have a television station. And they tell about their Supreme Court to the world as what they're doing. So we need to have that, a radio station maybe. We need to get onto Twitter. We need to get onto Facebook, Instagram, tell the world what we're doing. So whatever little good that we do, that also doesn't come out. So I think we need to do a lot of awareness and see what we can do about it. So on the whole, you see, it's time that we were to restructure the whole thing, revamp the whole thing, and make judiciary and the justice sector more progressive. And lastly, I'll just finish it with a quote or a rubayat from Umar Khayyam, which says, "Our love could thou and I with fate conspire to grasp this sorry scheme of things entire. Would not we shatter it to bits and then remold it nearer to the heart's desire?" Thank you so much. Thank you. I can be here if there's any question. If there are no questions, I'm really lucky.
I'm sure we have some questions. Yes,
Justice, thank you for your detailed explanation. I'd just like to bring you back to your earlier statement at the beginning of your talk, where you said
Thank you. Sorry. I'd just like to bring you back to your earlier part in your presentation, where you said that, judiciary is quite straightforward. Obviously, judiciary is part of, is one aspect.
No, I can just, sure.
It's one aspect of a triangular system. So you have an executive, you have a legislature, you have a judiciary. As an engineer, if I may give an engineering comparison, so it's like you have a production line, and your executive is the line itself. Your legislator is inputting the blueprint. So it's giving the instructions to the line how to perform. And the judiciary is like the quality control system.
That's right.
It will ensure that the production line behaves immaculately as per the instructions from the blueprint or the legislator.
Right.
But the issue is this. The issue is if the input, the blueprint or the legislation itself is in origin flawed, so you're instructing the line to produce a three-legged table, for example, then the judiciary or the quality control, in this case, will continuously ensure that the table will always have 3 legs, regardless, even though it's obvious it needs to have 4 legs.
Right.
So my point is this, that in Pakistan, there is an inherent flaw. The legislation was based on a certain principle, that the state would function according to Quran, Sunnah, Islamic lines.
Right.
But in reality, we see law in contradiction to this. For example, you have the FRDL Act 2005, the Fiscal Responsibility.
I've understood the question.
Yes. So my point is that you need to address the underlying dysfunctional nature
That's
of
right.
the state.
Fair enough.
Contradiction to its very basics.
That's very interesting.
If you see, I believe you understand my point here.
I have understood the question, if you allow me to answer. You see, it's in your engineering model, there is no constitution at the back, you see. Here we have a constitution at the back, so you can't have a three-legged whatever that you're developing because the constitution doesn't allow you to do that. So it's very simple. It's simple because there is a constitution. It tells you what to do. So if the executive or the other two wings are not doing according to the constitution, the quality control knows what to do. There's a book, follow this quality control. So I'm not really worried what you're supposed to do or not. I'm just going to implement the constitution. It tells you what to do. So I just need to keep implementing the constitution and make sure you just get corrected automatically because there is a book at the back that needs to be followed. So that's how I look at it. I might be wrong. But I think it's easy if the executive were to outstep itself or the legislature were to outstep the constitution because we have a fundamental basic document right there, you see. That needs to be followed. There is a margin of interpretation and all that, but there is a document at the back, which perhaps in the engineering model might be missing. So then everything falls in place. Every institution falls in place if we tell them to act according to the constitution. And currently, institutions which are larger than other institutions are interfering. Can that happen if you were to follow the constitution? That cannot happen. I mean, you have to act like an institution that the constitution allows you to work, and in that fashion. So I think the minute we start implementing the constitution and follow what the constitutional principles are, things do, to my mind, fall in place. I mean, there might be rough edges here and there, but largely you can, steer through it rather nicely. But that doesn't really happen. That doesn't really happen. So that's where the problem is. G.
Goodness me. Well, we have an enormous number of questions. Would we be all right, Justice Shah, if we just bundle perhaps 3 together?
Sure.
Just so I can try and get everybody.
Yeah.
So the 2 gentlemen here first. So if we start with Mr. Lambert. If I could ask everyone to keep their questions as concise as possible, that would be very appreciated.
Really wonderful address. I agree with everything you said today. The only question I have is in respect of 1843 and the power to issue directions in respect of fundamental rights. Is it time for the judiciary to recognize the separation of powers as a substantive limit on the power to issue directions? That is to say that they should not issue directions that would breach the separation of powers, but even to the extent they do, maybe do it proportionately so it doesn't really encroach.
I fully agree. I couldn't have said it better. Yes, we should do that. And we should maintain the separation of powers. And as I said, you see, I go forward and I say 184 could only be used to implement or enforce fundamental rights and not of the downtrodden, depressed classes which are mentioned in the Constitution, a class which is in trouble, has no other remedy, the state hasn't done anything about it, pulling them up. That's the kind of power to be utilized, not in daily matters. Yeah, certainly. Thank you.
Assalamu alaikum, sir. Thank you so much for that insightful speech. So with respect to your experience in judicial reform and everything, the Supreme Court has had a history of conforming in front of the powers to be, for example, in the Maulvi Tamizuddin case, DOSO, PCO judges. Do you envision a future where the courts, not only just the Supreme Court, but the lower courts as well, are free from these external pressures?
Well, that's what I'm saying. We should not even worry about this, because I've read you the oaths that we have. I mean, I just don't know how you falter and how you don't follow the Constitution. So, yes, to my mind, it's very clear. I mean, no matter what happens, nothing can ever happen. There can be no invasion if you were to just follow the Constitution. If the judiciary is there and it's together and it understands what the Constitution is and what is to be done, I think nothing can happen. But then there are problems within, so that's where it all goes wrong. That's all I can say. G.
Take the lady at the back next, right at the back, just behind you, yeah.
Thank you for that speech, and it was really enlightening, especially with relation to the gender-based violence. I wanted to ask that gender-based violence is not necessarily restricted to women. It also extends to people who identify as the third gender or identify with some other orientation. Sure. So what kind of work is being done in that area?
That's a good question. Of course, gender is not biological. The question is that we've just started sensitizing people and judges towards gender now. So there's been huge training going on, people understanding what stereotyping is and what gender is all about and the concept of gender. But I'm quite sure if we continue this way, we'll be attending to transgenders and other genders for that matter. But it'll take time. But we've at least started in that direction, and that's a welcome step forward. But I take your point. Yes, we need to move ahead and look at other shades of it also.
Assalamu alaikum, sir. Sir, I wanted to ask that the Transgender Protection Act of 2018 has a legal inconsistency in that it has a self-determined category of gender, which is very progressive. So if a man, like a biological man, identifies as a woman, he can legally go to Nadra and change his gender on the card. But if he then goes on to marry another man, he would be tried in the Sharia courts for sodomy.
Right.
So what do you think, that is this act for international reputation, or is it actually legally sustainable in the Constitution?
Well, I haven't gone through the act, but you raise a very important question. Yes. I mean, unless the whole thing is decriminalized also, yes, it doesn't go full circle. But I haven't looked at the law yet. I haven't seen it. But yes, I think there is an apparent inconsistency there. And I'll have to look at it and see how we can resolve it. But yes, point taken.
Hi, sir. My question is that regarding your DG Khan Cement case, you said that there is nothing etched in law. So my question is do you think that the ban notification being there, the Section 3 subsides that, or do you think the notification subsides the Section 3 in that?
I think that's a bit technical question, but yes, the notification, we said, holds for the ban because the law provides for that ban, because they can zone and they can create areas if they wish under the law that you're talking about. That's right. So we said, yes, it can create a zone and it provides in the public interest, they can come up with an area.
But my question is, doesn't the Section 3 upholds the notification subsides when...
No, it doesn't. It doesn't. It falls in place because Section 3 says that you need to seek permission and they need to grant you permission on the basis of public interest and it should not affect others. So they don't need to do it every time in a case. They can come up with a zone saying in this particular area, for example, you can't set up a sugar mill in the south because there's a water scarcity. So they could, under Section 3, issue a notification saying that this would be against public interest. So they don't have to do it case-wise. They can even come up with a zone in that sense. So that's what we thought was correct.
I think maybe we could move on.
We could probably have a discussion later on if you want.
Just so we can get around as much of the
Sure.
as we can.
Yeah, yeah.
Such
Yes.
demand for questions.
Yes, please, go ahead.
Yes, thank you so much for being here and for answering our questions in particular. So common law lawyers and constitutional lawyers in particular are generally very skeptical of judicial activism, and perhaps rightly so. But in the politically fraught context of Pakistan, where other state organs like the legislature and executive are able to uncontroversially overstep their democratic mandate, do you then feel that judicial activism takes on a new form? Does it perhaps become more necessary or more justifiable in a way we wouldn't otherwise see in common law countries? I would love to know your thoughts on that.
Well, you see, my view on, I think there is nothing so special or different about judicial activism. I think it's part and parcel of judicial review to my mind. I mean, judge ought to be active. I mean, if he thinks that something is wrong, he needs to interfere. So somehow my understanding as a judge has been that if I were to look at a problem and if I'm judicially reviewing a matter, I'm active, and if I think I'm, whatever I'm doing, to me, that is judicial activism. I mean, there's no special thing. I don't wear a special cap and I say, today I'll be doing judicial activism and today I'll be doing judicial restraint. I look at the circumstances of the case. These are the tools available to me under the banner of judicial review to me. So firstly, I think there is no special thing called judicial activism, because the minute you implement the Constitution, at times you call judicial activist in that context, which you're not, because you're just simply judicial reviewing. So yes, I think the judiciary can go ahead, if required, in a particular matter, and do judicial activism if required. This is actually, over the years, judicial activism and judicial restraint has been, because of the temperament a judge has. A lot of judges are conservative and just don't want to interfere, where I think that interference is not illegal. Both the terms are legal to my mind. There is nothing illegal about judicial activism. Judicial overreach is illegal, but judicial activism is illegal, so is judicial restraint. These are temperaments. So depending on what judge you get to decide your matter, that's how it will go in that direction to my mind. Yeah. Ji.
So we have a question just here, and then over to perhaps we could come over to this side of the room.
Assalamu alaikum. Jazakallah khair for your speech. The question I wanted to ask you was, yeah, I'm here, sorry.
Oh, sorry, I can't see you. Yes.
The question I wanted to ask you was that, you've referred to the Constitution of Pakistan so many times. The first article of the Constitution, I hope you remember it, it's that the state of Pakistan is based on, the Constitution is based on Islam.
That's right.
And you haven't actually referred to that, I think, in your speech today. So what role do you think, and most of us are Muslims here, you started your speech with Assalamu alaikum. What do you think that Islam plays a role in our day-to-day life in Pakistan and in the judiciary?
That's a tough one.
And don't you believe that, you've repeatedly said we need to implement the Constitution. Don't you believe that these problems that we're facing, from misogyny to, all these issues that we're facing in Pakistan, these problems have been solved by the Khulafa Rashidun, for example, Sayyidina Umar, Sayyidina Abu Bakr radiallahu anhum. Don't you think that we should implement their system to solve these problems?
Okay. So now, this is a very interesting question. You see, our Constitution starts off with saying that sovereignty lies with the Allah, and we have to come up with an order or a system which is in accordance with Islam and Sunnah. Now, very interestingly, the entire legal system that we run and the judges that function in that legal system are trained in the common law and not really in religion or Islam or the principles of Islam as such. If you look at our schooling throughout, we might have a subject called Islamiyat as a subject, but we haven't really gone through a proper schooling of Islam as such, where we would be well grounded in the principles of Islam, so that when we come out and implement, and the entire governance of the country is to be based on Islam, I think there is a dysfunctionality, a serious dysfunctionality. We don't know that, and we just, as a judge, throughout, I might have my own understanding of Islam, which is my own personal reading maybe, but there is no official course that we have to go through in Pakistan, or there is no syllabus that is to be followed, so that we go through basic principles and everybody is on the same page as far as Islam is concerned, so that we can implement that wherever it's required while deciding. So as far as judges are concerned, or as far as my judicial experience is concerned, we haven't come across any issue to that effect. I think the answer would be that the legislature needs to come up with a law considering that let there be debate in the parliament, and they can consider the Islamic aspects of a particular law or whatever they want to implement, and that is the law that we consider and implement. So as far as I'm concerned, I would just follow the law that comes out of the parliament, and that's, to me, I can't bring in my religion while deciding the case. That's not my domain. My domain is to follow the law of the land and the Constitution. And to me, fundamental rights the law and the constitution is supreme. And the Islam, if it's to come into law, it has to come via the parliament. And let the parliament debate about it, and whatever law they make, we are there to implement. So this has to be understood. I can't sit down and bring in my own religious beliefs into my jurisprudence, into my decision making. That'll be very chaotic, actually, and that'll create a lot of problems. So whatever you have to do, bring it into the parliament, make a law, and that law be the law of the land. That's as simple as that. Not everybody starts going and deciding what Islam is. That will be very chaotic, actually. Ji.
Assalamu alaikum.
I think this may need to be our last question. I know so many of you wanted to ask questions. I'm so sorry.
Assalamu alaikum. I really appreciate your answering all these wide range of questions. So you talked about the attributes which some of the judges need to. Yeah. So I think
I'm here. Afterwards, we can talk. I'm not going anywhere.
You mentioned.
I've traveled all the way from Pakistan. I can't fly out tonight. I'm here.
So you talked about the judicial courage and all the good values, including the freedom of speech and the freedom of values and the freedom of expression. My question is that there is a black spot on the face of Pakistani judiciary that we, as such, are not able to stand up to the establishment, especially when it comes to the issue of missing people. We have Masood Janjua, who is missing for several years. We have Naveed Butt, a renowned engineer. He is missing for last 8-9 years.
Several, yeah.
So the question is that so when you talked about the judicial courage, do you see it as a lacking on the part of the Supreme Court, that they're not being able to exhibit that courage you talked about?
Many things you're not supposed to say. I mean, it's quite understood. I'm saying that we need to have a model where you have judicial courage and judicial integrity. And if missing persons are missing, then there is something missing here. So you can, do the engineering of it if possible. So, yeah, we need people with courage, and this will never happen. So, things like this.
Perhaps I could just ask everyone to join me with one more round of applause.
I would just like to start off by firstly thanking my team, the LSESU Pakistan Development Society, each and every member of which has played their part in organizing this 5th edition of the LSE Future of Pakistan Conference. I would then like to thank our esteemed speakers, most of whom have traveled all the way from Pakistan, especially Justice Shah, whose words today are truly an inspiration for us all. I would also like to thank our partners in the event, specifically Dr. Nilanjan Sarkar and the LSE South Asia Center for their constant support, without whom I think it's impossible to do a public event at LSE. One person I would like to give a special shout out to is my friend Alim, someone who is not even part of Pakistan Development Society or LSE in fact, but has been a huge support throughout. And I can say for sure that this conference would not have been possible without him. Funnily enough, he's currently not here and is busy doing something related to the conference, but he's not even here to hear me say this about him. But alongside myself, the team has put in countless hours of effort into this conference to make our vision of this year's conference come true. It hasn't really been easy. Well, in fact, it's been nowhere near easy. There were several hurdles and numerous instances when we even questioned ourselves. But in the end, I believe it was all worth it. The Future of Pakistan Conference began as a vision, a means to connect students, the leaders of tomorrow, to the leaders of today who shape the future of Pakistan, while giving these leaders a platform to discuss the immense potential that Pakistan holds for South Asia and for the rest of the world. The Future of Pakistan Conference has evolved from a vision to the largest student-run conference in the entire world. And this year, we've worked to enlarge and amplify this platform. In the previous years, we've had the great privilege of hosting the sitting Prime Minister of the Islamic Republic of Pakistan, the Honourable Justice Qazi Faiz Isa, Ms. Hina Rabbani Khar, Ehsan Iqbal, Dr. Ishrat Hussain, Dr. Miftah Ismail, President of the Azad Kashmir, Senior Journalist Najam Sethi, Mr. Hamad Azhar, Barrister Etazaz Ehsan, and these are only a few of the names. I mean, we've worked really, really hard over the years. And these speakers have addressed the conference and engaged with the students present. These conferences have been an encapsulation of our societal aspirations, allowing students direct access to global leaders and policymakers while having constructive and productive discourse on the various challenges faced by Pakistan and creating greater awareness about Pakistan's development in the wider non-Pakistani community. As president of the LSESU Pakistan Development Society, I am personally a believer in top-down change, creating space for discourse and discussion at the highest levels of policymaking to create development outcomes that can benefit those in society who are in dire need of assistance. At the same time, Pakistan itself is in want of partners in the international community and seeks to demonstrate the considerable potential it owns that can be realized only through cooperation. Hence, as students of the London School of Economics and proud Pakistanis, very, very proud Pakistanis, we have aimed to play our small part in working towards a narrative of positive change in the country we call home. Our discussion panels this year have taken an embodiment of this principle, taking the toughest challenges faced by Pakistan today heads on and inviting our esteemed speakers to interact with an engaged audience over constructive solutions. It is only by working together under a united banner that we can create the change we know Pakistan deserves. As Pakistani students, I believe it is our moral obligation to go back and work for the betterment of this country. In the words of my leader, do not be overwhelmed by the enormity of the task at hand. You are made of sterling material and are second to none. You are a nation whose history is replete with people of wonderful grit, character, and heroism. Live up to your tradition and add to a chapter of glory, because you are the future of Pakistan. ये वतन तुम्हारा है और तुम हो पासबान इसके. पाकिस्तान जिंदाबाद. Justice Shah is here for a while. He's happy to take any questions, to chat with any of you. So for anyone who missed out on the Q&A session, he's here to interact with all of you.